Right, welcome. Good to see so many of you here. Nearly 300 people have signed up for this talk, and it's great to see a number of familiar names on the attendee list. Hello, John.
Hi.
You can tell it's a major flagship seminar by the fact that John's got a suit on and I've got a shirt on. It's not the standard Zoominar, this one. Standards are obviously higher in the planning department, hence the tie and the suit. This is the last episode in the Property Pick and Mix seminar series that we've been putting on. We were due to be on a week or so ago. We had to postpone it, I'm sorry for that. A 3-day trial of mine got shoehorned in at the last minute. So we've been forced to postpone to today. Videos of the other talks are available for any of you who want to see them again or want to see them for the first time. If you just email marketing@kingschambers.com, they'll send you out a link. I've put that address at the end of my slides, so when you get those at the end of this, then you'll be able to use it. The Pick and Mix series is intended to showcase the breadth of experience and expertise in the property department, the whole range of seniorities. Chambers is uniquely placed, aside from the property department, to deal with development cases, in part because of the strength of the planning, local government and highways department, of which John is a member. That is a nationally renowned department, from silks down to juniors. And so what that really means is that Kings can offer a one-stop shop for development cases, covering both private law and public law issues. That's really behind what lies behind the request for John to join us in the session today. Those of you who do planning and local government work will be well aware of John. At the risk of embarrassing him, he's very highly regarded. He was in the Supreme Court without a silk this year. And I've worked with John on a number of cases. They seem to be increasing in recent times as well. They're the sort of cases that don't fit neatly into a box. And that's that's really the point of this talk, that to developers, they don't really care what area of law is engaged in their case. They just have an objective and they want advice about how they can go about achieving it. So that's really where we as a Chambers can help. We can work out between us who needs to do what, and we can end up producing the advice that covers the full range of what's required. So John and I conceived this talk having discussed these sorts of issues. I'm aware that there are planning lawyers here and property lawyers. That creates an immediate difficulty in terms of the level at which the seminar can be pitched. Some of the things that we talk about will be very familiar to some of you, perhaps very unfamiliar to the rest of you, but hopefully everyone will find something of value in what we've got to talk about today. You are all on mute. It would be unmanageable to do anything else with the sort of numbers that we've got. As I say, nearly 300 or so of you. If you have any queries, please use the chat function, and hopefully we'll have time at the end to deal with questions. So I think that's about it in terms of introductions. So John, over to you.
Good afternoon, everyone. Can I repeat Geraint's apology? What you're about to hear, if you're an experienced planner, will be some basic stuff, but it's pitched at a level that everyone will be able, I hope, to follow. So it's really designed for people who maybe know a little but not very much about planning. But hopefully there'll be some interesting bits for those even who are experienced planning lawyers as well. So now I'm going to do, with great trepidation, try and share my screen, and fingers crossed this works. Is that all right, Geraint?
Yep, that's worked.
Fantastic. Right. Right, just kick off then. The purpose of the planning system, what is it? Well, it's in broad terms to regulate the use and development of land in the public interest. That has certain consequences, as does the fact that planning permission normally runs with the land. That's the general rule. It can be displaced by express provision in the permission, but if it doesn't say anything, it runs with the land with the successors of entitled. It follows from that as a general rule, planning isn't concerned with private interests or the particular purpose of an individual occupier. And I've cited a very old authority which established that and still holds good. And nor is it necessary procedurally, in most cases, as I say, there's some minor exceptions, to have ownership or control of land to apply for, or indeed to obtain planning permission in respect of it. There are, as I say, some minor exceptions. For example, I think in the case of there is a procedure under Section 96A of the Town and Country Planning Act, which allows you to apply for minor amendments. That can only be done insofar as the applicant has an interest in the relevant part of the land. But the general rule is you don't need to own or control land to apply permission for it, although there might not be that much point in applying for it in that case. That, however, that's the general position, but it's subject to a number of significant caveats. The first one, another procedural issue, even though you don't have to own the land, you have to certify when you make an application whether anybody else has an interest in the land and that you've given them notice of the application. Another example is that although private interests as a general rule aren't material to planning, they can be where they merge with the public interest. So where if public policy indicates that particular private interests ought to be protected, then they can be material. And there's a range of different examples of that. The oldest and leading case on it is Stringer, which is a case about Jodrell Bank, the impact on the operation of the telescope of development in the area. Jodrell Bank has been a fertile ground for planning lawyers because I myself have done, I think, 2 or 3 cases involving development where the major issue was the impact on Jodrell Bank. Great Portland Estates, that was a case about policies which protected long-standing industrial uses in the face of encroaching office development. Again, it was held that in that case, public interest in preserving particular businesses. And again, a fairly common example, personal circumstances, human rights and so forth are in fact frequently, this is often called on exception to the general rule, are treated as material planning considerations, for example, in the cases of gypsies. Third example, or third caveat, if a planning obligation is required, as it often is, in particular for housing, for example, to secure the provision of affordable housing as part of a scheme, the planning authority will in practice normally require that all of those with an interest in the land enter into the agreement in order to ensure that it binds them. So those are the three caveats. The fourth one is the one that I'm going to talk about more today, which is that even although private interests, issues of ownership and so forth aren't, as a general rule, vital or even relevant in many cases to the determination of planning applications, they are still critical, of course, to the implementation of any permissions that are obtained, because unless you have control of the land and the relevant rights, you won't be able to do what you have permission for. And nowhere is that more true than in the case of access, because as Geraint says, we seem to be having an increasing number of cases where overlapping issues of ownership and planning in highways law are coming in. So again, going back to basics, it may be entirely self-evident, but just in case it isn't, national policy tells us that securing safe and suitable access to a development site is a vital matter. Depending on the nature of the application may itself include full details or more or less full details of the proposed means of access. If it's a full application, if it's an outline application, that is a sort of a sketch, just establishing the principle of development, it may or may not include details of the access. In some cases, it simply may identify the proposed point of access. In other ones, it will be very similar to a full application with more or less complete details of the access. But whichever way the application is made, the planning authority will, in virtually all cases, still need to have sufficient information and evidence to be satisfied that adequate access can, at least in principle, be obtained before they grant consent. And secondly, when they grant consent, they will normally make it conditional on delivery of the access or relevant parts of it. If it's a large development, for example, it may be phased. Access to part 1 may be required from the outset, part 2 may be required before the occupation of the dwellings in phase 2 and so forth. In addition, planning authorities may sometimes require improvements or alterations to other parts of the road network which aren't in the control or ownership of the applicant before the development can proceed. For example, if there is a capacity issue on the road and the development would exacerbate it, then it may be that widening or some other improvement is required before the development can go ahead. And normally that's controlled by a what's called a Grampian condition from the case I've cited there, which is a negatively worded condition saying you shall not proceed with your development until the widening or whatever other improvement is required occurs, which you may have to pay for, by the way. Problems. Where land is that is required for access is wholly owned by the applicant, the position is normally straightforward. But where it involves third-party rights or third-party land or land over which there are third-party rights, problems can arise. For example, the third party may attempt to hold the developer to ransom, or maybe flat out unwilling, if they don't like the development, to grant the necessary consent, whatever price is offered. In other cases, it might not be clear whether the developer already has sufficient rights to enable them to deliver the access. For example, they may not know whether they've got a private right of way which would be sufficient to allow access into the development, or it may be there's a boundary dispute or some other property law issue. And in that case, and that's the sort of thing where when I've had a case that's raised issues like that, I've got Geraint and other members of chambers involved. How can such issues be resolved? Well, in general, I would suggest it's nearly always sensible, and it doesn't always occur. In fact, in a number of cases we've dealt with together, this hasn't occurred, that really considerable thought is given to what land, what rights, and what consents may be required for whatever the proposed means of access is before an application is made. And I say that primarily because once permission is granted, it may be much harder to revise the scheme in order to overcome any issues that may crop up later than if you do it at the outset when you may have a bit more freedom. Equally, I'd probably add that it may be that, you know, once the person whose land you require or whose consent you require for access knows that you have planning permission, they're obviously going to, in most cases, seek to get a chunk of your profit. And it may be a bit cheaper to do it if you do it before you've actually got permission. If that's not possible, however, and if it looks like once you broach the issue that the third party is pretty recalcitrant or is demanding an unreasonable sum, your options, you've got limited options, but not no options. One, at least in the case of large developments, may be to try and persuade the planning authority or the highway authority to exercise, or at least threaten to exercise in order to sort of persuade the third party the powers of compulsory purchase. Now, there are a number of powers which are relevant in this context. One from the 1990 Planning Act, the main one is section 226. This authorises local planning authorities to make compulsory purchase orders if either A, they think the acquisition of the relevant land will facilitate the carrying out of development, redevelopment or improvement on or in relation to the land, so that will cover some access required to facilitate development, or B, it's required for a purpose which is necessary to achieve in the proper planning of the area. So it's a pretty broad power available to the planning authority. Also importantly, it doesn't matter whether the planning authority itself intends to carry out the development. So it can do it in order to facilitate development by a commercial developer. It does, however, require confirmation by the Secretary of State, and the Secretary of State's general test when deciding whether to confirm a compulsory purchase order is whether or not he's satisfied that there is a compelling case in the public interest for overriding private rights. If an order is confirmed, incidentally, it may extinguish any existing rights of way and certain other rights. There are also powers for the highway authority to compulsory purchase land in order to provide access. In particular, sections 239 and 240 of the 1980 Highways Act allow it to acquire land for construction or improvement of a highway, which is to be maintainable at the public expense, and any land required in connection with it. The power is, however, subject to distance limits, which are set out in the schedules to the Act. You'll see there, the main one is 220 yards from the middle of the proposed highway in relation to land required for the construction of such a highway. So depending on the circumstances of the case, it may or may not be sufficient to overcome such issues. If you need a lot of land a long way away, it may be less suitable. But as I say, the main issue will probably be in these cases persuading a planning authority or a highway authority to invoke their powers. They won't want to do so because A, it's a lot of trouble. B, they have to incur expense and you'll have to pay them. You'll have to agree to indemnify them for that. And in any event, it can take some time, and the Secretary of State will, as I say, apply the test of requiring a sufficiently compelling case in the public interest. So in short, they're not going to want to do it for every case, and they most probably won't want to do it for most small cases. It'll be bigger cases where they've got a real interest in seeing this land or a wider site being developed. If they refuse to do it, in principle, you can try to judicially review the authority, but in practice, that's unlikely to be, you're unlikely to be successful in most cases, because ultimately it's a discretionary decision. They don't have a duty to do it. They have a power to do it. And unless they seriously misdirect themselves or act utterly unreasonably, you're not likely to get the High Court interested in overturning their decision. If compulsory purchase is not a viable option for whatever reason, I think you then just have to consider, in most cases at least, whether there are any alternatives and whether you can amend the scheme even though you've already got permission. And that can be done for those, again, not familiar with planning legislation. There are two main powers to obtain amendments to permissions. First one is through Section 73 of the 1990 Planning Act, and the second through Section 96A. Section 73 allows you to apply for a variation of conditions. So if access is conditioned, you can try and vary that through that. Section 96A allows non-material amendments, and that may be suitable in certain cases as well. Right. A further issue, and again, this is one that Geraint and I have had in, fairly recently in practice, is where a planning authority has been seeking not only to get satisfactory access from a physical point of view, but also to ensure that the access carries public rights. It's a full public highway for vehicles, people on foot and so forth. Again, if the developer is the owner of the land, not usually an issue, because creating full public highway requires dedication by the owner of the land, which means the freehold owner, and so that won't be a problem normally. And it's usually achieved through what's known as a Section 38 agreement, although there are other means of doing it. However, it can be a problem where a developer has only secured a private right of access. So a developer may have secured from the neighbouring landowner access, which is adequate in the private law sense for the development. But if the planning authority says, no, that's not good enough, we want it to be a public road through your site, you'll need to go back to the other landowner to get their consent, either to convey the land to you or to agree to dedicate it. And that's true even where the land in question is already subject to lesser public rights. So for example, if there is a bridleway on the relevant road or relevant portion of the road, and the planning authority wants it to be a full public highway, even if it's a bridleway which is maintainable, maintainable by the highway authority, they normally won't have sufficient interest in the land to create a full public highway because the freehold owner will have retained the subsoil, part of which will be required for the full highway. So that's a problem. And again, that's a problem, however, which can be overcome by the use of compulsory purchase powers. Again, if the planning authority, highway authority is willing to exercise them. There's another possible route, which has got all sorts of difficulties and restrictions of its own through Section 228 of the Highways Act, where there's a procedure for trying to compel the highway authority to adopt it as a public highway. But to a large extent, this problem may be a historic one, because very recently the Court of Appeal has issued a judgment in a case called DB Symmetry Limited, in which they held that planning conditions requiring the dedication of a public right-of-way are inherently unreasonable and unlawful. And they overturned a High Court judgment which said it's all fact sensitive, and in some cases it's reasonable, in some cases it's not. It's interesting because it's been an issue in planning law for 60 odd years, going back to at least a case called Hall and Shoreham, which the Court of Appeal held is good law still. And its effect is, as I've described, to say that ipso facto, a condition requiring dedication of land as a public highway as a condition of planning permission is unlawful. Although the judge below had disagreed and thought it just, as I say, turned on the facts. Now, the Court of Appeal noted, however, that at least historically, the same thing wasn't true of planning obligations. And indeed, this is one of the advantages of planning obligations, that they could be used to get a developer to cede land as a public highway, whereas a planning condition couldn't. However, they threw potentially a spanner into the works. They left it dangling, at least, when they noted that the position may have changed as a result of Regulation 122 of the Community Infrastructure Levy regulations. And that the reason for that is that Regulation 122 imposes a prohibition on planning authorities taking into account any planning obligation when deciding whether to grant permission, unless it satisfies the same legal tests that the courts have historically applied to planning conditions. The court didn't answer this question. As I say, it just left it open, but it's clearly going to be, well, it's very likely to be a live issue in another case, because at some point, some developer is going to say, I'm not giving you it by planning obligation either. So you'll need to watch that space, or this space, for further news on that. That, I hope I've not overrun terribly. That is my portion of the talk. I think Geraint mentioned at the end, we're going to take questions at the end via the chat function. So if you've got anything, take a note and ping it up there later on. Thank you very much for listening. Thanks. Geraint.
Thanks very much, John. The great thing about working alongside John is that he's one of the few people who can pronounce my name. So I always like that. In the private law sense, the keys to access in relation to development sites are rights of way, and so that's obviously access over someone else's land, and access to the site over other land that the developer might own. So rights of way over someone else's land and access over your own land, but on the way to the development site. I'm going to touch on only one aspect of rights of way. It's an important development in recent years that hasn't really received the attention that I think it deserves. But in the limited time available, I'm going to focus mostly on issues concerning developers' own land that's proposed to be used for access. So let me just start sharing my screen, hopefully. John, is that working? Excellent, thank you. So, what links the following? Quiz time. So that's the first one, the second one, and the third one. Okay, so we've got Blackpool, we've got £5, and we've got a horse. Now, there's no particular reason for that being a horse dressed in a tweed suit and cap, other than that I absolutely love it. And the answer, which I'm sure almost all of you got, is Section 62 of the Blackpool Improvement Act, 1879. That is an act which you can't even find on Westlaw anymore. It's an act that required permission from the Blackpool Corporation for the gaining of access to the street for a horse. And there's a penalty of £5 if the landowner failed to make the request. So why have I put that up? It's to illustrate this point, which dealt with Section 62, Marshall and Blackpool Corporation. which confirmed the existence of the common law right that every landowner enjoys to access the highway from his or her land. Now, so subject to planning, as far as common law is concerned, you've got land that is alongside the highway, you can access the highway. So now this may look like something scribbled on the back of an envelope, but in fact, it was something scribbled on an iPad with an iPencil. So it's highly technical stuff. It's the limit of my technical expertise, but it's really designed to illustrate this point, which is that again, subject always to planning and highway considerations, the landowner can access his or her land at any point along the highway, can open up and access anywhere that he or she chooses. So just changing the layout slightly here we've got a highway coming in from the right-hand side, crossing over another highway, going into the development land. Now, it may well be that this is the development. We'll come across this layout a number of occasions as I go through my talk. And it may well be that road that's coming in from the east is a better road, it's bigger capacity, wider, and that's where the developer wants the bulk of the access to come from. It goes along a highway, crosses a highway and enters the development land, subject to conditions imposed by the planning authority, the highways. There's no problem there, there's no private law issues involved in this. But what if we change it slightly? So here, the difference is that the north-south road isn't a highway anymore. It might be a private road, it might be something like a bridleway. Now, in fact, John and I have dealt with a case in which there was a bridleway in this location. So the access is coming in from the east, and then you get to that square portion, the dotted portion there, where access needs to cross something that isn't a full public highway. It's only a bridleway, and a bridleway is essentially something over which there are no vehicular rights of way. So you get to that square, which is tantalizingly close to your development land. The question is, can you reach it? And it's a question that brings in the concept of ad medium filum, which is it's good to see that Latin is still going strong in 2020 commercial development cases. So the ad medium filum presumption is actually two different presumptions. So the first one is that the owner of the land abutting a road, whatever kind of road it is also presumed to be the owner of the adjoining section of road up to the middle line. So you own your half of the road that you front onto. That's the first presumption. The second presumption is that when the owner of land that fronts onto the road sells it, they're presumed to convey with it that half that's next to their land. And there's a development on that which comes from the Micklethwaite case that I've cited there, which is that if the owner of the land owns both sides of the road and they sell the far side, then they are presumed to convey with that land the far half of the road, and they keep the near half of the road. So how does that impact on our development site here? Well, what it does is that the developer will, unless the presumption is rebutted, be presumed to own the left-hand half of the road, the one that is contiguous with the development land. The third party will own the road that is contiguous with its land. And in fact, on the facts of a case that I've dealt with, the developer had sold the third party land to the third party. So that Micklethwaite presumption applied, so that even though the transfer to the third party was by reference to a plan which appeared to exclude the half of the road, the presumption would mean that the third party got the half of road that was contiguous with the third party land. So what that in effect meant was that access to the development land was made that much easier, because you had when you reach the dotted square there, the first half of the dotted square would be on land owned by the third party, and there was a reservation of rights of way in relation to that. And then the second half of the dotted square there is already owned by the developer. So I mentioned here that the ad medium filum presumption can be rebutted, and I'm not going to go into this in any detail. It's not particularly easy to rebut the presumptions. I've mentioned the three of the main cases that deal with rebutting it in the slide there. Just very quickly following on from that, here's an example of a land registry title plan. And you can see that the red edging there, obviously we all know that will be a general boundary, so that could be wrong. But when you look at it, it doesn't appear to, the land owned as part of the George doesn't appear to include any of the roads surrounding the George. Now, leaving whether or not the ad medium filum presumption has applied, if the George might well own half of the roads all the way around it, or more than that, but the land registry doesn't usually show ownership of roads. So it's something to bear in mind. It's something that can easily pass you by. The registrar is allowed to register or indicate ownership of roads on title plans, but just usually doesn't. So that's ad medium filum. The next aspect of private law rights in relation to the developer's own land that I want to talk about is restrictive covenants. So what happens if the development site is located away from the highway, as we've got here in blue? And there's no right of way for the developer to get from the highway to the development land. What can the developer do? Well, sometimes the developer already owns land in between, so plot X here. Sometimes the developer buys plot X to facilitate access to the development land. Does ownership of plot X provide the solution to the developer's problem in terms of access? And the answer to that is not necessarily. This is an example of a restrictive covenant in a case that I'm going to show you in a moment. The owner of plot X in that case was required by restrictive covenant not to use or permit or suffer to be used the land hereby conveyed, or any part thereof, or any building or erection now at any time hereafter erected thereon, for any trade, business, or manufacture, but will use the same as a private residence only. And in this case, the developer wanted to create an access over plot X to its development site at the rear. The development site wasn't subject to the restrictive covenant. Only plot X was subject to the restrictive covenant. Court of Appeal in Jarvis and Holmes was the forum for discussing this particular covenant. The court decided that covenant prevented the developer from using plot X, so using the land that was subject to the restrictive covenant as access for the site behind. In effect, the Court of Appeal construed that covenant as being permissive as private residence only, so a single use was permitted under the terms of that covenant, and the covenant basically not to use that land for anything else, including an access to somewhere else. And that was the case, in fact, even though there was a house on plot X, so it was being used as a private residence. It's just that the access meant that it wasn't going to be used as a private residence only. Now, the thing to bear in mind with this is that that's just one case that's dealt with on its own facts. But what we're going to see is that dealing with these sorts of issues, it's always a question of construction. The small details are really important. Small changes in wording can make a big difference. And that's illustrated by a comparison between the Jarvis Holmes case that we've just looked at and the Elliott and Safeway case here. So I've set out the covenant there in the slide. So a covenant not to use plot X at any time, not at any time hereafter, to carry on or permit to be carried on upon plot X or any part of plot X, any business comprising the sale and purchase of all types of fuel and lubricants for all types of mechanically propelled vehicles. Don't you just love the way that lawyers can't say petrol station? So what happened here was that Safeway built a garage, and it built a garage off plot X. So it built a garage on land that wasn't subject to the restrictive covenants, and it wanted to create the access across the burdened land. So far, so similar to Jarvis Holmes. But here, the court permitted that. So here, access was allowed over plot X in a way that it wasn't allowed in the Jarvis Holmes case. It was argued that as the route across plot X was the key to the use of the other land as a petrol station, that it was absolutely integral to the petrol station. The petrol station just couldn't be used without it. It was part and parcel of it, went the argument. And so you can't treat the access separately from the petrol station, they said. And if you can't treat them separately, then the access on plot X surely must be treated as being the use of plot X as a petrol station. And the court said no. Basically, you've got to look really closely at the wording of the covenant, and it doesn't always mean that you take an absolutely literal view. But in that case, the covenant was not to carry out on the land the sale of petrol. And the Court of Appeal said, well, you are not, this scheme will not involve the sale of petrol on the burdened land. So therefore, there's no breach. There'd be no breach of covenant. So that is what I want to say in relation to the use of the developer's own land in order to achieve access to the development site. Just now I want to talk about rights of way. So the developer doesn't own the land over which access is going to be taken and needs to rely upon a right of way to get there. Now, rights of way are obviously it's an enormous topic or collection of topics. I'm just going to focus on one aspect of it, and it's one that's based on another of my cases, actually, at the risk of sounding big-headed. So the developer built up a significant number of plots of land over time. Now, I've just put 3 on here, and that's pretty messy as it is. In this case, the developer had lots of titles that are built up over time. And the plan was to develop it all as a single unified estate. The developer had a right of way, you can see on the right-hand side there, private right of way, that led to the first parcel, to parcel A in blue. And the question was whether that private right of way giving access to parcel A would be sufficient, because the developer needed to drive along the private right of way, turn onto parcel A, drive through onto parcels B and C with construction traffic, if nothing else, to actually build out the estate. And then once built, the various owners of the houses, you can see that the black lines, by the way, are intended to be estate roads. So the various owners of the houses built off those estate roads would then also need to use the private right of way. The question was that permissible? You can see there's a potential highway to the north, And that represents the fact that this is another one of those cases where John got involved and was talking about the impact of that potential highway on the situation. From a private will point of view, it didn't matter that there might be an alternative route of access that everyone could use via this highway at the north. In a private law sense, the question was whether parcels B and C could use the private right-of-way to the east. And the first port of call is the well-known case of Harrison Flower. So you have a right-of-way to one place, you can't use that right-of-way to then go on to somewhere, to a different plot of land. That's the classic position, very well known. And the question really is there any wriggle room in that? You might think, well, what if the use to be made of the extra portion of land is fairly minor? And the answer given by the Court of Appeal in Peacock and Custons was that it doesn't matter in terms of the principle. The principle still applies. That was a case to do with agricultural land. There was a right of way to one agricultural field with a further field beyond, and the owner of the fields wanted to use a right of way to get to the first field and then onto the second field. It had a right of way for the first field, but not for the second, and it only went on to the second a couple of times a year. It's a really minor use of the right of way. The Court of Appeal said it doesn't matter, it's still a trespass. So in terms of wriggle room, there is wriggle room, and it's the concept of ancillary use. Ancillary use came from the national, is found in National Trust and White. It's a very well-known case. So there's a right of way for the benefit of the National Trust for its site called Figsbury Ring in Salisbury. You can see there that cars would drive up the right of way, and then the National Trust wanted them to park on that car park, and then for people to get out and walk along the dotted line back along the right of way to reach the site. Now, the car park wasn't the benefited land. It did not have the benefit of the right of way, at least expressly. And ultimately, as is quite well known, I think that the court decided that was fine, because the use of the right of way was only ancillary, they said, to the use of the right of way for the benefit of Figsbury Ring, which was the land that had the benefit of it. There was no use of the right of way of the car park, rather, for its own sake. So, more recently, the Court of Appeal in Das and Linden Mews looked at this point. Now, this image, it looks more professional than mine. That's because it was an embedded image from the Court of Appeal judgment in a later case. I'm not responsible for this one. Basically, what happened in Das and Linden Mews is that number 4 there in blue had a right of way over the yellow land, over Linden Mews, benefit of number 4. One decided that he wanted to park in the garden beyond the left-hand green land. There was no right of way to the green land, though, at least expressly. So the question was, does the right of way to number 4 allow the owner to park in the garden to number 4? No. Here's the terms of the grant, right to and from number 4, and the court said, no, you can't do that. But then we get to the important case, which is Gore and Naheed in 2017. And in Gore and Naheed, you don't need to know look at the detail of this plan. It's again one of the Court of Appeal's own embedded images. But basically here there was a right of way for the benefit of the green land, called the granary, over the yellow land. So it went from the highway across the yellow land, which was just a driveway, up to the granary. And that was a right of way that was granted in 1921. At some point far more recently, a garage was built, which is the grey land there next to the granary. And the owner of the granary occupied the garage and acquired title to it through adverse possession. As a result of that, as soon as the owner of the granary owned the garage, they could use the garage for any purposes they want. They owned it. But the question was whether they could get to the garage via the right of way, because the right of way was for the benefit of the Greenland. Now, you might think it was a bit cheeky that you take the land through adverse possession, and then you also try to use a prior right of way to get to and from it. But that's what happened, and the facts, you'd think, are very similar to the Das facts. Right of way potentially over the yellow land to get to somewhere new. But the decision that was reached was the exact opposite. The decision in Gore and Heed was that the right of way did extend to the garage, even though it wasn't even in existence at the time of the creation of the right of way. This is the right of way. The right for the owners and occupiers of the granary to go and return along and over the private entrance road or way coloured yellow for all purposes connected with the use and occupation of the granary, but not further or otherwise. And the answer to why these two cases that appear to be similar in terms of their facts led to completely opposite decisions lies in the wording of the two grants, the two rights of way. So the top one there is Das. So in Das, the right to pass and repass to and from the highway to number 4. The second one is the Gore and Heed one, which is the right to go and return, so to and from, along the road coloured yellow, for all purposes connected with the use and occupation of the granary. So what the Court of Appeal in Gore and Heed did was they interpreted Das as being a very restricted grant, that it was just a grant of a right-of-way between 2 points, the highway to number 4. And they said that when you construe the grant in that case, in Gore and Heed, it was more expansive than that. It was the right to go up and down the yellow drive for all purposes connected with the use and enjoyment of the granary. And that included then the garage when it was built, because the garage was used and enjoyed as with the granary. So here I've set out mainly for your purposes in future when you get the hard copy of these slides. I'm not going to just read out the statements of principle in Gore and Heed, but the moral of it is that the rule in Harris and Flower is not as simple as it first appears. It's not as simple as saying, well, you've got a right of way to one place, you can't use it to get to another place. The answer is that it depends. It depends on the wording of the grant. There is some wriggle room. Now, it's unlikely to help large developments, but it may be beneficial to smaller developments, particularly as in the case of Gore, which isn't a development case per se, but in Gore, it was access to a garage that was off the main site, and that might be useful to smaller developments. So it's useful. Gore and Heed is useful in terms of developers because it widens the principle. It allows for this wriggle room in Harris and Flower. But the downside of that is that when you're looking at fine distinctions in terms of the wording of a grant, that leads to uncertainty is inherent in that. The problem with uncertainty is developers don't like that. And developers don't like that because buyers don't like that, particularly buyers, solicitors, and even more so, buyers, lenders. If you can't give your buyers and your buyers' lenders certainty, then developers end up often having to buy out the third-party interest anyway. And so that is all from me. Thank you very much. I'm just going to check the chat function now, if I can. I'm going to stop sharing my screen.
I think there's one question, quite a long question. There was another one about section 228 which has disappeared. But I've had a chance to read this question, Geraint. Shall I have a go at it first? It may be that you have to chip in at some point.
Yeah.
from what I gather from this,
Sorry, John, I'm not sure that that everyone else can see the question, so maybe you need to read it out for everyone else to hear first.
Well, I'll read it out. It's from anonymous attendee. Planning permission granted for development with access. Development land is landlocked. Neighbouring land with a dwelling is owned by a private resident who claims to own the boundary fence wall dividing the plots. But for the boundary fence wall, there's a highway that runs up to the boundary fence. If the fence didn't exist, the developer would have access to the land. What options are available for the developer to proceed with the development, i.e. break through the wall? And then there's comparison to, I think, one of the slides. I'm not sure I can visualize this exactly right, and it maybe I've got another one. But if I think in theory, Geraint's mentioned is a common law right of access for adjoining landowners onto the highway. It can be interfered with by the highway authority, but if it's been interfered with by a private individual, then there may well be a cause of action there. I wouldn't say break through it in the first instance. I probably want to have a look at it. A lot may turn on the precise physical circumstances and the order of events. So but if it truly is the position that the highway runs right up to the developer's land, then prima facie they've got a right of access, which shouldn't be interfered with, it seems to me, subject to possibly, unless it was dedicated with that wall there or some other reason.
Yeah, I mean, from my point of view, what I'd be looking at with that is I'd be trying to work out on what basis this private resident claims to own this wall. So as I understand it, the question is positing a situation where you've got the development site here, you've got the highway here, and the only thing that's separating them is a wall that someone else claims to own. Now, if the developer owns the site, and then you've got the highway here, it would seem surprising for a third party to retain ownership of that wall. If they do, as a matter of fact, retain ownership of that wall and the sliver of land that it's sat on, then there wouldn't be the right to the private law right to get out, because there would be, if it's a single leaf wall, there'd be so much land that isn't owned by the developer, and that very much would be a ransom strip. Then you'd start looking at ways of necessity and so on, and that's when John was talking about the order of events, whether a way of necessity was created when the different parcels of land were separated off, would be where I'd look at next.
Yeah, I mean, it may be that it's not part of the highway either as well. It might, if the wall predated the highway, either the highway may not actually run under the wall, as Geraint said, so there would be some intervening land on which the wall sits, in which case no common law right. Or alternatively, if it does, it may have been dedicated subject to that wall. Or I think the answer is we can't answer it in the abstract. You'd have to look quite carefully at the facts of the case. But there may well be a remedy, but I think, as I say, you need to sort of get a magnifying glass and look through the documents and the history of it. I think we've got a few more questions, Geraint, and I note the time we've overrun a bit, so maybe we should move on. Let's hold a second one. Establish oak tree in boundary hedge. Now, so I'll read it out, sorry, in case people can't see it. Have a case of an established oak tree formerly in boundary hedge, now on the front boundary of residential property at the back edge of the footway. Property owner considers the tree's responsibility of the highway authority. So oak tree in boundary hedge.
So just for everyone else, so is a boundary that's is a tree in the boundary hedge between the pavement and presumably some sort of front garden, the responsibility of the highway authority?
Well, I'd imagine it's owned by the property owner on it, because most people's boundary fences and boundary hedges are on their property, not on the highway.
Yeah, again, it's going to be really fact specific. That it's where the edge of it is. I mean, the roots will go down below the top two spits, presumably.
And it's quite complicated case law, I think, on bits where you have overhanging and the roots bits, and which bits of it become the part of the highway and the responsibility of the highway authority. Again, so I'm sorry, but again, I think it's one of those that we'd have to look into in some detail to form a view on. I'd have to remind myself of those old authorities on it as well. But if it is subject to those issues, if it's normally would have assumed that the boundary hedges and other vegetation are part of the property, or the adjoining owner's property, not the highway. But maybe need to look at it in a bit more detail. I think we've actually got 3 more from Charles Stevens. I don't know if they're the same question in different parts. On my estate, a developer was granted, I presume, permission for 90 houses over a hammerhead. At the time, a company owned the Hammershead ransom strip and the moiety of. Does that mean the moiety of the ancient highway beyond? Is the planning permission unlawful as they never contacted the company? And is the adoption of the access road also unlawful? So again, I'm not sure I understand it all, but there was permission granted, or company owns a ransom strip and half of the, presumably maybe the Ad Medium Phelum, half of the ancient highway beyond.
So it's a third-party company owning part of the land in relation to which permission was granted, I think.
Yeah. So they never contacted the company. So this depends. Depends whether it was part of the application site, because sometimes you don't show all of the access, but I'm going to assume for the purpose of the question that you normally have a red edge plan on the planning application. The red edge includes land owned by the company, allegedly has a ransom strip over it, and they weren't notified. Yes, there probably was a breach then of the regulations, or there should have been a certificate confirming that and saying that they've been given notice. That said, it doesn't really get you anywhere, because I'm going to assume as well that permission was granted a while ago. You'd need to challenge, if you were an adjoining owner and not notified, and you can show prejudice because, for example, you weren't notified then by the planning authority when they carried out publicity, you could conceivably bring a claim for judicial review, but you'd have to do it within 6 weeks. And so I assume this is probably not the case here. So even if there was a breach of the regulations, probably too late to do anything about it, unless I'm wrong about that assumption. And the second question is the adoption of the access road over the said land unlawful. If the access road has been adopted as public highway, as adopted by the highway authority, and there is an owner, a freehold owner of part of that land who did not consent to it, then yes, there is a problem there. They seem to think they've adopted something they haven't actually adopted. Yes, you need you need the consent of all of those with the relevant interests in the land. So if there's part of the land one of the owners agreement wasn't obtained, then yes, there may be an issue, and it may be that not all of it is actually a highway. I don't know where that will leave things, but yes, there's a problem there that needs investigating potentially.
And then there's a question here that looks like one for me. A developer has asked us for a license for a route over our land. However, the request has now turned into one for on-site storage for development works in the vicinity of our private land. Is a license an appropriate instrument for this? We don't want to give exclusive possession, but realistically, the developer would want to secure its equipment. Now, I infer from that your concern about this, Patience, is that you don't want to run the risk of granting a lease rather than a license, because that potentially confers additional security on the developer. The facts of that, the facts that you're looking at here, being a temporary expedient, I think would work against that being construed as a lease. But it would just be a matter of drafting. I would imagine that there's nothing inherently wrong with a license for something like that. And in fact, you say that the developer would want to secure its equipment. Well, a license should be adequate for it to be able to secure its equipment. And then the last one, John, is one for you.
Well, on the 228, yeah, there's two 228 questions. One about how useful is it when ownership of a private street is unknown. The other one is how receptive are most highway authorities to section 228? Can they be forced? Taking the last question first, can they be forced? Yes, they can. If all of the conditions are met under section 228, they can be forced by the majority, what is it, owners in rateable possession, or whatever the terminology is. In principle, they can, provided all the other criteria are met. How receptive are they to it? I have limited experience in this. I don't think it doesn't often crop up, but I have some experience in it, and they weren't receptive in the case when we're doing it, but they had good reason potentially not to be receptive, because they were saying that the statutory criteria weren't met, and I think they may have been right about it. So the first question, how useful when ownership isn't known? Well, it depends how much is unknown, because in order to compel the highway authority or street authority, you need to have the majority of owners of the street compel them by the magistrate's court procedure. So if you don't know anybody that owns it, it's going to be pretty useless, because you won't be able to compel them. If you know the majority of them and you're all in agreement, and the whole spectrum of cases in between, I think. So it can be. Having said that, the criteria is often difficult to meet. For example, it can't already be it can't already be maintainable at the public expense. So if it's a lower category highway, then you can't, but it's maintainable at the public expense, you can't then upgrade it. As I say, probably the biggest reason for it being difficult in practice is that if you're trying to use it for this purpose to overcome the fact you don't know who owns the road, and you can't rely for some reason on the ad medium feelum presumption, it may not be able to get you around that unless, as I say, you know enough about it to be able to identify a willing majority of owners. So, Geraint, do you want to add anything?
No, I don't. I think that's it now. We've gone quarter of an hour or so beyond the allotted time. I think that's everything. If it's not, then apologies for that. So I just want to thank you, John, actually, for coming along and doing this today. And thank you to everyone else for being here. As I say, sorry that it was postponed, but hopefully it was useful. And remember to get hold of marketing@kingschambers.com if you want to get the link to the other materials from the other talks. Thank you very much.
Thank you for all attending, and thank you, Geraint.
Yes.